Lordship, can I mention, Lordship? It's for upgradation, Lordship. Upgradation.
No upgradations, please.
Very urgent, Lordship. This case pending 2016.
It's now we are moving forward. Don't worry. Yes.
Item number 1.
I am here for the petition. I am for the respondent in this matter.
It's come for extension.
Yes. Now,
Which
this is that matter where this matter is being heard by your lordships. Mr. Ghosh was arguing, and then I intervened. And the question of in situ promotion of those employees, whether they are entitled to benefit of the earlier of the Supreme Court on an identical issue. So the contempt petition was filed during the pendency of hearing before your lordships, and your lordships had been pleased to grant its order.
Let's have a date fixed so that it can be fine.
Yes, date may be fixed. Date may be fixed.
Yes.
The promotional list was published. One of the employee has filed an application before the Central Administrative Tribunal, Hyderabad Bench. Tribunal has allowed the
Yeah, we remember.
That your lordships will
You
hear.
are claiming that it is covered by that.
Not by- because
Because yes,
there is
Murthy is-
affidavit, not only Supreme Court decision.
What was the name of that Murthy case?
Murthy and Siddiqui. Both two matters.
So therefore, we are saying, let's.
Sir, I shall argue.
Date, my lord. We all are.
That is what we are saying. Let you give us a date on which we can take it up after 1 week or 2 weeks, whatever you tell us.
12 August.
12th.
12 August.
Will ask what is the date? You got it. No, just a minute.
Yes. Have a look. It's a Tuesday.
Yes, 12th August.
12 August.
Item number 2.
Lordship, in item number 2, I beg to appear for the petitioner. The matter is appearing for correction.
What happened? What's the mistake?
My lord, I didn't mention the matter.
What? Huh? Oh. Matter has been listed. There was a typographical error in the last line. Date was wrongly mentioned. That we have corrected, and it will come on 4th August.
Grateful, your lordships.
3.
For the petition. But on the last occasion, my lord has directed, directed the Union of India to give an supplementary or given whether the order of the Patna High Court has been given effective. The Patna High Court order has been given effective. I am filing it by way of supplementary affidavit. My lord, page 14 of the supplementary affidavit. Yes, I have served them the copy, but I went to serve them the copy, but they didn't take the copy. Department of Union of India, Minister of Law and Justice didn't take the copy. But the Patna High Court order has to give an effect to page 14 of the supplementary affidavit. But I have another judgment.
Yes. Yep.
February by 2017 by a memo, they have given effect to the order of the Patna High. That the great pay of 4600.
Yes.
There is also a judgment K.M. Thomas, which has been filed by the Kerala High Court and which has been upheld by the Supreme Court. I'm judgment of the judgment. The prayers of the way 950 has come after the tribunal order way number 950 of 2012 filed before the tribunal by the respondent. Hearing was for the declaration that the application is entitled and eligible to be granted rate pay of 4600 in the post of junior English translator. The effect from 1/1/2000 is based on annexure dash dated 13/11/2009 by the government of India as has been granted for similar incumbents under the annexure A4. But if we come to the operative part of this judgment has been upheld by the Honorable Kerala High Court. And this judgment has been upheld by the Supreme Court, Honorable Supreme Court.
Kerala High Court, which paragraph you are reading?
I am reading at kindly come to the last paragraph operative part of the order, page 12. Page 12, page 11, last paragraph. OP Cat 142 of 2014, this basis was contended by them. The such an incumbent would be entitled to the first and second financial accreditation in the post of senior Hindi translator only with the grade of 4600 and 4800 respectively. This contention was overruled by the tribunal and by the division bench of this court in the previous round of litigation. it was held that the initial grade pay in the junior in the translator was 600 and the applicants with the entitled cost and the second financial upgradation MSc in the post of JA junior in the translator with grade pay of 4800 and 5400 respectively. Since this issue in this regard is thus substantially and conclusively covered in the previous round of litigation, the present contention raised by the official authority concerned that the issue raised hearing regarding initial pay in the post of junior in the translator and that the issue raised in the previous round of litigation is distinct in so far it is related only to the post second financial upgradation grade pay as per MSc section is nothing but rehashing and refactoring the old unsuccessful contention as new ones. Though at the first glance, this contention appears to be accepted, but the same was untenable, unsound in view of the aspects of it. And they have, and the Honorable Kerala High Court has directed the Union of India to release the payment within 3 months. Judgment has been upheld by the Honorable
Right. Why are you worried? I will reply your tweet. You conclude. Which photo? Diction which has been done. Yes, you were supposed to file affidavit. They have filed affidavit.
My lord, the file is in Delhi, my lord. We have instructed on the very same day to the department, my lord. So,
Oh.
file is to come, my lord. So, we will, as been instructed, my lord. From Delhi, they have asked for the file in Kolkata office. Is yet to come, my lord. So, they said, ki if my lord may so pleases, so my lord. If a week's time may be granted, my lord, they will come.
No, no, they have already said you have implemented. They have
Yes,
filed.
my lord. By there, I have gone through the affidavit.
Yes.
It says that it has been implemented.
Yes.
Only, my lord, indulgence I will seek, my lord. Let that official report instruction may come, my lord.
For what?
My lord,
This is your communication.
Yes, my lord. It is
Then-
there. Let a official communication.
They are admitting that it is their.
I am not admitting, not denying anything. Why are you putting your words in my mouth? I am neither admitting anything, nor denying anything. It is there. It is a record which I am. My lord, let a official instruction come.
Nothing. You just find out about this. We
Yes,
are not
my
going to ask you to file anything now.
No, I will not file anything.
Just in response to the last order, the union.
Item number 4.
Your Lordship, I'm praying for not this week as the learned counsel appearing in this matter is not available.
Is
Not available, Mr. Ajay Chaudhary. This is a Air Force matter. It will.
as prayed. As paid list after 1 week.
Five.
Kindly make it not. I have been instructed to appear on behalf of the petitioner in this matter.
You are for the petitioner. You are for the petitioner.
Here, my lord, the point is very simple. On the earlier date, my lord, my matter was heard. Only the point was whether the petitioner is entitled to the interest on gratuity. My lord, since yes, my lord, that part. Since my lord, initially at the time of retirement, he was undergoing, my lord, the criminal case, which was subsequently quashed and acquitted.
Criminal case. What is his date of retirement?
Thank you, dear. 31st of January 2018, my lord. Yes, I'm so thankful, my lord. 31st of January, my lord, 2018 was the date of retirement.
And when he was acquitted?
My lord, the order was passed of the Honorable High Court on 8th of May 2023.
Yes. And when he has been paid the DCRG?
My lord, he has been, my lord, paid with the DCRG, my lord, on 14th of November 2023.
Did you, they were party to the criminal proceeding?
My lord, no, this was my lord.
When did you
419.
communicate? When did you communicate the,
Yes, my lord, I have communicated this order of the court, my lord, I tell your lordship, 21st of August 2023. So, my lord, the point only, my lord, I was agitating to your lordship, my lord, my claim for gratuity was rejected on this court that this criminal case was pending, and there is a provision in the railway service pension rules for not payment of gratuity till the conclusion of the judicial proceeding or the departmental proceeding. This is why it is not paid, and as a corollary, you cannot be given with the interest. Now, there is an impugned order. If I can directly take your lordship to that, which your lordship will see at page number 33. Relevant part your lordship will find page number 84, fourth paragraph from top.
so prior to this also you have filed an OA?
Yes. That original application, my lord, the direction for rescind order was given.
Where is the provision?
Page number, yes, my lord, page number provision, my lord, which says that gratuity may not be paid.
No, there are two things. One, it says cannot be paid, and the other is how it is to be determined whether there will be a liability for interest. Both provisions, where are they?
But the parent provision, my lord, subject to correction of my learned senior, my lord, I have found, my lord, in railway service pension rules, my lord, 10(1)(c). It একবার দিন, দাদা।
There are two administrative provisions. Service pension rules. Then C.
10(1)(c). এটা দিয়ে দিন, স্যার। এই যে। The 10 says provisional pension where departmental or judicial proceeding may be pending. But one says about the pension and gratuity, but kindly comes down to C, clause C. Clause C, my lord, says no gratuity shall be paid to the railway servant until the conclusion of the departmental or judicial proceedings and issue of final order thereon. provided that where the detrimental proceeding have been instituted under the provision of Railway Service Disciplinary Appeal Rules 1968 for imposing any other court clause, the payment of gratuity shall be authorized to be paid. This is not relevant in my part. So only enabling provision for the railways not to give the gratuity is 10(1)(c). Subject to correction of my land.
After 10(1)(c),
Yes. My lord, if I request your lordship, my lord, yes, I take your lordship, my lord, one master circular, because lordship was of the view that what are the enabling provisions that I have got the liability or I have got the entitlement. Sorry, master circular.
and gratuity is defined.
But that provision, my lord, if I request your lordship, my lord, that this master circular, if I request your lordship to see directly, page numbers are written at the bottom. My lord, to see, my lord, directly page number 19.
Just give us a minute, please.
That's, I'm sorry, I'm so sorry. But may I refer to, my lord, paragraph number 2? I'm so sorry.
Paragraph number
12, my lord, in page number 20.
of this master circular.
Yes. Oh, I'm so sorry, my lord. The master circular, my lord, paragraph, page number 19. The page numbers are written in the bottom. But that talks about the gratuity and the relevant provision, my lord. I will be referring to page number 20, paragraph number 12.
Otherwise, if there is a delayed payment,
Yes.
is there any provision for grant of interest?
My lord, in the payment of gratuity act there is. So, my lord, I on the earlier occasion was trying to, my lord, make the submission to your lordship. I did not see this, my lord. I must, my lord, bow down to your lordship. I was trying to make the submission to your lordship that there is a provision that yes, gratuity may not be paid, but there is no provision of saying by saying that no interest will be also paid or will be paid. So that lacuna, my lord, has been filled by the overriding provision of the payment of gratuity act, and my lord, this has been held by this honorable court as well. May I just refer to your lordship the judgment? In the judgment, my lord, I'll be requesting your lordship, my lord, to see, my lord, the facts are entirely similar. See, my lord, from paragraph number 12 onwards. I must be candid, my lord. I borrowed my submission from paragraph number 12 to 16.
In paragraph 18,
Yes, ma'am.
the court has quoted, from where it has quoted, on account of some fault.
The issue as to whether the petitioner was at fault was determined. The right to a claim interest remained dormant during the pendency of the criminal proceeding, and such entitlement revived upon acquittal in the proceeding. It would thus be erroneous to conclude that the gratuity payable to the petitioner on attaining the age of superannuation was withheld on account of some fault.
Yes, from where this quotation?
My case.
No, from where this quotation has been taken, on account of some fault.
Follow, my lord. Possibly, my lord, Rule 27 of, my lord, the Railway Service Pension Rules. I just take your lordship to that once.
No, because the judgment must have quoted earlier. Therefore, we are asking. We have not read the entire thing.
Follow, my lord. Follow your lordship.
Must have been quoted. Therefore, it has been picked up.
I tell your lordship.
This is precisely what we were asking you. There is some provision which contemplates if it is on account of any fault, then only it can be.
My lord, paragraph number, Rule 87 one says, my lord, of the Railway Service Pension Rules.
27,
87 of the Railway Service Pension Rules.
87.
Yes. There is a provision for interest on the gratuity.
Perhaps this may not be applicable. Perhaps this may not be relevant to your case.
But, yes. But Payment of Gratuity Act also, my lord, provides a provision where, my lord, where the gratuity may not be paid. That, my lord, perhaps was the, if I take your lordship to that once, my lord, it would be, my lord, 4(6) of the Payment of Gratuity Act.
No, 4(6) is quoted in the judgment.
Yes, it says about in which situations the gratuity will not be paid. So there, my lord, the element of the fault on the part of the employee, my lord, is there.
No, in paragraph 18, from where this expression has been quoted. You have a copy of the act.
Payment of Gratuity Act. Yes. My lord, I also, my lord, could get the letter, my lord, which your lordship has seen, my lord, in that master circular mentioned of 1990.
Paragraph 12.
Yes. I have also got that letter from the internet itself.
No, it is clear.
The letter, my lord, which they refer, the original letter, my lord, I've got. If your lordship wants to.
Yes. This is also a railway employee.
Yes.
Yes. Yes, you are relying on some other.
That later, my lord, that is referred in paragraph number 12.
Fifteen 491.
Yes. The paragraph number 2, 1.
Okay. As far as so procedure for yes,
Time of retirement, if the disciplinary proceeding or judicial proceeding is pending, so we are in view of the Rule 10C, my lord, I can withhold the gratuity. And if the after exoneration of the charges, my lord, the gratuity will be paid, and my lord, within 3 months from the date of communication of this order, my lord. So, my lord, I have paid the gratuity within 3 months from the date of communication of the order. And lordship kindly see. Ten C, my lord.
yes, we have it. It is before us.
And my lord, my lord can refer to this rule, my lord. I am also relied on this rule, my lord. Within 3 months from the date of exoneration.
Which rule?
That is a 2(1)(a).
Of which rule, sir? 21A
2(1)(a), just now,
The
my
letter,
lord,
my lord.
of this letter.
in such case, if the railway segment is exonerated of all charges, and where the gratuity is paid on the conclusion of such proceeding, the payment of gratuity will be deemed to have fallen due on the date following the date of retirement by board's letter number so and so. If the payment of gratuity has been authorized after 3 months from the date of his retirement, interest will be allowed beyond the period of 3 months from the date of retirement. So, I have paid the gratuity for a period of 3 months, my lord. And my lord, actually, my lord, from the Rule 10C, my lord, I withheld the gratuity. And after exoneration of the charges, my lord, by the Honorable Ranchi High Court, my lord, I have paid the gratuity within 3 months. So, my lord, there is no default on the part of the railway department, my lord. And my lord, before this way, my lord, the petitioner filed earlier way,
Huh?
petitioner filed earlier way before the learned tribes on the ground of all the retirement benefit.
This extract at para 12, where is it in the letter? This extract at para 12,
Yes.
where is it in the letter?
But, this has been, my lord, incorporated pursuant to the letter.
This has been incorporated.
Yes, pursuant to the letter that is, my lord, mentioned.
No, but in this letter, we don't find that.
But that para 2(1)(a), but there are 2 letters mentioned, my lord. I have got one 1991.
So maybe it is which
1993 or 83, my lord, I did not find, my lord.
Anyway,
But my lord, this stands to be the RB.
this master circular is much after this 91 letters, so we need not go into that. Yes. So
uh, as per rule, we obtain C, will have withheld the gratuity. And will have the petitioner filed earlier OA before the learned tribunal regarding retirement, all the retirement benefits, including gratuity. And will have the tribunal remand the matter to the authority. Will have the authority pass that order, only will have withheld the gratuity. And after exoneration of the charges, will have the authority will pay the gratuity within 3 months from the date of communication of that order. Will have.
very good. Yes, take down.
Will have
Yes.
Sorry, we'll have only one copy of the judgment of the Supreme Court and handed over your lordships. But only we have big judgment, Milord. Only will lordship kindly see the paragraph 69.
You are giving us one judgment, how we can see it?
But sorry, Milord, only Milord, I have searched today morning, Milord. 2009 5 SCC, page 313, Act 67, paragraph 69, Milord. Milord, I am sorry, Milord. One. But there is a pending proceeding, Milord, the Supreme Court in case they will not entitle the pendency of the case.
Paragraph 69. Somewhere there was a mention regarding the rate of interest. Somewhere we have seen that rate of interest fixed by the central government. Where does it say?
The payment of gratuity act.
No, in one of these, perhaps the railway pension or.
But 87, my lord, kindly sees once.
Oh, yes, must be 87.
Seven, my lord.
At the rate applicable to state railway provident fund amount. And this judgment has granted interest at which rate? Muhammad Farid judgment?
The region.
10%.
10%.
This, see, we can do that. Because this says
That is correct. This is that provided the delay payment was not caused on account of failure of the servant to comply with the procedure. And here it says, it is if the delay is by the authority. Here it is not that we can say this for interest rate guidance at that time deposit. That safest deposit. The 4 times. It was recorded on a 5 made on payment fee 411.
Six. My lord, I am appearing on behalf of the petitioner. My lord, petitioner before your lordship is the son of a deceased employee of postal department. My lord. He has prayed for compassionate appointment. My lord, when the issue is pending before the authority concerned, tribunal has proceeded as if the authority concerned has decided the issue and taken it into consideration that your action is, my lord, barred by limitation. When the issue is pending before the authority, my lord, in no canon of imagination, it can be stated the your claim is
This has to be given to the learned advocate for the petitioner in that case.
Oh, that one.
In the earlier case. No, not in this case. Yes.
my lord, entire ordering suffers from perversity. I show your lordship that issue is pending before the authority concerned. My lord, kindly come to page 40.
No, so it's still pending.
Yes, still pending. No decision has come. My lord, however, your case will be placed in the next circle relaxation, page 40, my lord, of the your case will be placed in the next circle relaxation committee meeting for third time whenever it is due to be held. This issue is in compliance with the order of the CAT number such and such. Next page, my lord. As per existing norms, the case of Joydev Bauri will be further considered.
How many times it has been considered? What is the date of death of your father?
2000.
2000.
2000. How many times it has been considered?
3 times, my lord. But they have promised, my lord, it is a question of promissory estoppel on their
Promise.
my lord.
We'll have some learning today. Yes.
My lord, kindly come to page 42
Yes.
again. And 42, my lord, here also, my lord, again, the issue.
Sir, on which dates it has been considered earlier? Tell us just the 3 dates on which it has been considered and rejected.
Well, that has not been annexed here, my lord. The difficulty, but the High Court has also left it open, my lord. Kindly see the earlier.
High Court.
Yes, my lord. Coordinate bench. It is the second round.
Which page, please?
My lord, page 21. Page 20 starts from 20, and relevant portion is at page 21. The court is not inclined to prevent the authority concerned from considering the candidature of the petitioner number 1 for appointment on compassionate ground under the died in harness category, even after a long lapse of 14 years. Then, after the direction of Honorable High Court, no decision is coming from the end of the authority concerned, my lord. At least we know, my lord, the reason is the heartbeat of any decision, because I challenge in the earlier round of litigation, I challenged the mode of allocating the marks. Then they have submitted before the Honorable Tribunal as well as to the High Court. They would consider our case. Well, no reason is coming from the end of the authority. Then, my lord, I have made a representation before the authority concerned, my lord. No reply has given. Then, my lord, we went page 46, my lord, the representation. And then, my lord, we went before the Honorable Tribunal, and the learned tribunal has arrived at the conclusion that as if the authority concerned has already decided the issue. And on the ground of delay. Because, my lord, their decision has enkindled hope in the mind of the petitioner, my lord. Even, my lord, from the order itself shows that there is no discussion about the High Court decision. Whenever the High Court has specifically held that that even while a long lapse of 14 years does not create any bar to consider the case of the petitioner. And they themselves have assured, my lord, to consider afresh the candidature of the petitioner.
High Court order was at which page?
Page 20 and relevant page at 21.
This is WP and CT 30.
Yes, ma'am. First paragraph as well as second paragraph. The court is not inclined to prevent the authority concerned from considering the candidature of the petitioner number 1 for appointment on compassionate appointment under diet in hardness category even after long lapse of 14 years. But we do not find any illegality on the part of this for not accommodating the petitioner till today against the available vacancy post under diet in. Next paragraph, the learned tribunal in impugned order dated 20th August 2014 has also specifically recorded the issue of compassionate appointment of the petitioner number 1 would be considered in the next CRC meeting by way of reconsideration of entire issue. Therefore, the said learned tribunal did not issue any specific direction to the respondent authority. We do not find any error or infirmity in the impugned decision of the tribunal. After this direction, no decision is forthcoming from the part of the authority concerned. There is no discussion about the neither High Court order.
Order was first on 24/4.
Now it is best that the issue should be given a quietus. Enough is enough. Yes, that's all. Yes.
Sir,
Take it
I
up.
have to submission the order passed by the tribunal is
7.
But I am for the respondent in this matter. On the writ petition which they have filed, they did not challenge the actual original order passed by the learned tribunal. They have challenged the review order, madam.
Who has? Oh, it is Union of India's writ petition.
Yes, ma'am. The writ petition is at all, madam, defective.
We had given them time to file the OA order. They have not done. None appears for the petitioner.
In August, ma'am.
Why? How they are not interested? Why are you?
I am suffering because, madam,
How we have not passed any interim order?
no, not, but the 22 months salary they did not give, madam.
So who is stopping you? You get the order implemented. We have not passed any interim order. One extra book. There is one administrative here, one in your rack, one here.
Lord, I'm praying for not this week. The senior advocate, Mr. Shorab Anundi, is out of station.
You are for the respondent
/ applicant.
Inform the respondent also.
on account of unavailability of
Nine.
Yes.
Why we have 8? What is problem?
One has to be returned. Why should we have 2 books? Return one to the library. Both of us have one. Return it. Ask him to return it. Don't keep it in.
Yes, my lord. I am for the petition. My lord, petitioner has been inducted in the Eastern Railway, my lord, after 20 years service of the army. He was in army department. After superannuation, he has joined in the Eastern Railway, my lord, Sialda division. Initially, he was posted on Namkhana, my lord, which was the distance of 110 kilometers from his residence. And thereafter, his own request, he has been transferred in the another place in the next meter, Akra. And after within 6 months, he has been taken and the transfer again, another, my lord, the Malda division, my lord, which is the another division from Sialda division, my lord. And in this respect, my lord, the one day he was called by the officer, in the page number, my lord, page number 18, my lord. 18, my lord, he was called and he was stated, my lord, that he will be transferred from Sialda division to another division. And he was given the request to interfere in the inquiry upon the staff of the grievances. But on that plea, my lord, he was called again in the office, and the proposal of transfer was taken by the DA authority, my lord. DA authority, my page number 62. And after the DA authority, my lord, and he has been taken transfer to Malda division, my lord, from Sialda division, my lord. And they have stated that by the power of the MSOP, my lord, module schedule of power, my lord. And page number 71, my lord. 71, my lord, para 3, it is stated that they can transfer only 1 year. But the transfer is for 5 years, my lord. For page number 50, my lord. Page number 51, my lord. Who was ordered transfer along with the post, Malda division, my lord. Along with the post has been transferred to Malda division, how the lien is to be maintained in Sealdah division. That has been stated in the last paragraph, my lord. The period of 8/3/24 on issue this order, waiting for final release of the division, the lien of staff will be maintained Sealdah division and entirely. But Sealdah division only at the lien, in respect of lien, my lord, only 2 years lien can be maintained. But he has taken with post 5 years. But how the lien has been maintained is to be maintained, my lord. And this transfer is they have stated, department has stated that is the administrative interest. And what is the administrative? Any administrative interest can be transferred from the when there is a requirement by the other division. And that requisition was not given. And suo motu he has been taken the transfer, my lord. And not only that, my lord, in the division there is vacancy. 46 vacancy was there in the same post, my lord. And when there is a available vacancy, and how he has been taken to another division, my lord. And not only that, it is a division to division transfer, and the GM approval is required, my lord. As for schedule of power, my lord, they cannot do so, my lord. And they have replied that as for schedule, they can do the same. But in the schedule, it is reflected, para 3, that only up to 1 year he can be transferred. And not only that, my lord, in the transfer order, prior to the date of transfer, he has been released. হ্যাঁ ওরাই দিয়েছে ডিপার্টমেন্ট দিয়েছে 71 ডিপার্টমেন্ট
Yes, what is wrong with the transfer order?
Yes, my lord. In the respect of the transfer order, my lord, the two application has been preferred, my lord, the appeal on 53, page number 53, on 11/3/2024, and also 13/3/2024. That was not disposed of, my lord. And for who is the
Page?
page 53 and 57. 57. Annexure Annexure A5 and A6, my lord. Against the said transfer as a major representation, my lord. That was not disposed of, my lord. For who is the petitioner has gone before the tribunal, and tribunal has passed the order only has to see the administrative interest was there. But the administrative interest was not there as because it is reflected in the transfer order.
Page 57, A6.
A6. No, A6.
Where
Oh, where annexure? Sorry. 57. 57, mile. 53 and 50C, A6. In the way.
A6.
In the way annexure on it.
What is the date of A6?
Date of, my lord? 53. A5, 1. Or 13/3/2024. One is 11/3/2004 and again 13/3/2024. Two representatives were preferred, my lord, against the same. But the honor in the impugned order, my lord, the learned honorable tribunal has not considered the actually suffering of the petitioner, my lord. He is only one member of his family to look after the family. His mother is ill, my lord. But he has been intentionally motivatively he has transferred it, my lord. That is the difficulty, my lord, now. And not only the transfer order itself is irregular as because it is not proper as 5 years transfer with post cannot be transferred and the lien is not to be transferred.
7 is not a representation. What are you saying? A6 is not a representation.
Huh? এখানে আছে তো এদিকে ওয়েতে আছে ওয়েতে আছে হ্যাঁ another one 25 and 29 is also, my lord. It was the annexure of OA, and now the writ petition, my lord, 25 and 27 in the writ petition. Twenty-nine, sorry. 25 and 29. Yeah.
You have not raised anything. 11/3/24 representation. No ground has been raised. Anything.
My transfer order is page 23, but itself was challenged, my lord. Before the tribunal, my lord. Okay. Same day তো বলে দিয়েছি।
JRL.
No grounds. There is no
Yes.
grounds.
No, my lord, transfer,
There is
whether the
no-
transfer order is valid or not, my lord. And it is transferred by the DRM only, my lord. And how can a DRM can transfer to the another one division to another division?
He can.
No, my lord, as per sophist, my lord.
No. You come to the transfer order.
Transfer order, my lord, page number 20.
He is the competent authority, DRM and SDH.
Yes, my lord.
They have given
23, my lord.
Yes.
My lord. On approval of the competent authority, my DRM.
Yes.
The DRM is the competent authority. Whether money that is the annexure 5 we will see, my lord. Page number 71.
Page number 70. Your page is impossible to find. We don't know.
71, my lord, which has been annexed by the reply, on the reply, my lord. 71, my lord, annexure 5.
Yes.
They have stated, my lord, in para 3, my lord.
Yes.
The full power in respect of up to period of 1 year without finance concurrence, my lord. And the transfer order is for 5 years, my lord. That is the discrepancy. The DRM can tell only one year.
You are a non-gazetted staff.
Yes. No, officer, my lord.
Station master is
Group C staff.
Station master is
Group C staff. Yeah, yes,
what post he was holding?
Station master.
Station master is not
Group C, my lord.
Group C.
Yes, my lord. Only Group D staff can be transferred by the DRM. Only Group C, when there is a DM is the authority, my lord.
You are non-gazetted.
Yes, non-gazetted staff.
Yes, but you have not raised any issue. Your representation, you have not said anything about this.
The transfer order itself has been challenged, my lord. It is admitted.
Yes.
Transfer order has been challenged.
Yes.
A transfer order is clear, my lord. The post he has been transferred. But how the lien has been maintained, my lord? 2 years cannot be taken by the lien more than 2 years, my lord. That is the established rule also there. There is a provision, my lord. Retention of lien. The lien of the permanent railway servant appointed under another central or state government office may be retained only for 2 years.
We don't know what this annexure 5 is. We don't know what it is. You have just annexed a page where you have got it. What is this? From which provision? Nothing is there.
They are reply, my lord.
This is annexed.
Reply of the railway, it is stated, my lord.
Yes.
It has been annexed with the respondent in the reply, my lord. Annexure 5 in the reply.
Yes, there is nothing wrong.
Yes.
There is nothing wrong.
No, in the transfer order itself is not valid.
All right, we'll consider this. Yes, take down. Ordinance Council for the We have one judgment fixed. After this, we'll not take up matters pre-recess. We'll be online with Jalpaiguri.
Item number 1.
My lord, I appear on behalf of the respondent, my lord.
See if the appellant has joined. There is still 1 minute left. Wait for 2 minutes.
For the appellant.
Ready to come online. Well, we have allowed the appeal and the writ petition is dismissed.
Much obliged.
Item number 10.
My lord, Mr. Didojas Chakraborty appearing for petitioner, my lord, he is lying ill, my lord. He is lying ill, my lord. He has not come to court. Dijodas Chakraborty, Mr. Dijodas Chakraborty. I'm praying for not the shoot, lordship. Not the shoot.
There is
Item number 11.
I am for the respondent number 2 to 4, Lordship. I am for the respondent number 2 to 4.
so he is appearing for which respondents?
I am for the respondent number 2.
CRIJF, my lord.
ICRI, Indian Council for Agriculture Research. 2 to 4.
He is for the CRI.
My lord, the
ICAR.
respondent number 2. 2, 3, 4, he is appearing.
CRI.
Lordship. ICR, not CIR. ICR, CRIJF, either Symphony or ICAR.
It is CRI, sir, in your application. It is in the way it is CIR. CRI, not ICR. How you are saying ICR?
Indian Council, this matter related to ICAR, CRIJF, CRIJF, CRIJF.
Huh?
CRIJF, I am for CRIJF, CRIJF, Indian Council of Indian Central Institute of Jute and Research Institute, CRIJF.
Central Research Institute of Jute and Allied Fibers.
Yes.
So CRIJ, yes.
Yes.
What is the issue?
The order impugned is that, my lord, they have annexed the certified copy, my lord, 7 February 2025, my lord. Thereby, my lord, the tribunal dismissed my application. So the point is, my lord, an advertisement for, my lord, recruitment was issued in the year 2009, my lord. For the post of, my lord, junior clerk, 4 posts were for the unreserved category, my lord. If your lordship may kindly consider page number 35, which is a legible copy of the advertisement. 6 posts were, my lord, advertised. Out of that 6 posts, my lord, 4 were for unreserved category, and 1 post therein was reserved for, my lord, the PWD category, my lord. 34 is the, my lord, paper publication. 35 is the, my lord, legible copy. My lord, I applied for the unreserved category. My lord, I was called for the written examination, written test. I was successful in the written examination. I was called for the typewriting test. I came out to be successful in the typewriting test, my lord. Thereafter there was police verification, my lord. It is my information that there was no adverse report from the police. And my lord, thereafter, my lord, I was asked to, my lord, submit this attestation form at page 56, which is required for candidates considered for first entry to the ICAR service. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . My lord, after I submitted this attestation form, my lord, there was no information. Then my lord, I submitted a representation, which your lordship may kindly find at page 39, 3rd of August 2011, my lord.
Page
39, my lord, 39, 3 lines. And at page 40, my lord, the response that I have received from the CRI.
attestation form, when did you submit?
My lord, this was, my lord, 3rd of August 2011, my lord. Below, my lord, left hand side.
What is the date?
My lord, 3rd of August 2011, my lord.
Where do we get this date?
My lord, below left hand side, my lord. Below the letter, left hand side. After with profound regards.
Page 63.
Page 39, my lord. 60.
No, we are asking you when you submitted the attestation form.
Attestation form, my lord, attestation form. I'm sorry, my lord. Attestation form, my lord, the last page, 63. It's
26.
26/6/2010. 26 June, my lord, 2010.
So when the final list was published?
My lord, no list was published. I waited for a substantial period, my lord, period of time. Then I submitted this representation at page 39, my lord.
Then what did they do?
Then, my lord, the response I received at page 40. But here they say, my lord, it is to inform that your case could not be considered due to non-availability of vacancy under DR direct recruitment quota. The matter was already clarified to you by the Chief Administration Officer in the presence of the undersigned when you visited our institute with your father during the last December, January. My lord, we say that this never happened, whatever it might be, my lord. However, the matter is once again clarified to you as such. The advertisement for filling up 6 vacancies of lower division clerk was published in the Bartaman newspaper on 8th of April 2009 in anticipation that new posts will be granted under LDC by the ICAR New Delhi. But later on, when cadre strength revised, it was found that only 3 posts could be filled up through DR as per the then recruitment rules. As such, first 3 candidates in the merit list got appointment, and as you ranked 4th in the merit list, you did not get the appointment. My lord, this is for the first time I get to know, my lord, that there was a merit list prepared and I stood 4th in that merit list. And my lord, the advertisement was for 4 unreserved category of posts. Now they say, my lord, in the response they say, my lord, it was in anticipation of vacancy and only 3 was sanctioned or approved, and therefore, my lord, only 3 persons were appointed, and you being the 4th person, you were not appointed. My lord, this is for the first time we get to know, my lord. My lord, thereafter, my lord, I assailed this response, my lord, through a writ petition. My lord, that writ petition got dismissed for default. My lord, since this matter was pertaining to the tribunal, my lord, thereafter I approached the learned tribunal. The learned tribunal said that unless you, my lord, withdraw the writ petition and have a liberty from the High Court to approach this tribunal, we will not entertain your original application. My lord, I came back to this honorable court. My lord, I mentioned the matter. My lord, got the matter withdrawn with a liberty to approach the tribunal afresh. Thereafter, my lord, we have approached the tribunal with by filing the original application being 351 of 2014. And my lord, this order was, my lord, reply and rejoinders were directed to be submitted. And this order dated 7th of February 2025 have been passed. My lord, in the rejoinder, my lord, new facts were, my lord, revealed, which were not, my lord, transpiring from the response that we had received at page 40. My lord, the reply is from page 64 onward, the reply submitted by the respondents before the learned tribunal. Here they say, my lord, at paragraph 4 of the reply, my lord, that in response to press advertisement, the institute has received 2578 applications. After screening, 471 are called for written test. Only 20 candidates fulfill the minimum criteria fixed and were called for typing test. My lord, I was called for typing test. The following candidates in order of merit list. My lord, page 66 is the merit list, which was never published, my lord. My lord, the fourth person is me, the petitioner, Somrat Chatterjee. In the reply, they mention that at the relevant point of time, the institute has only 2 vacancies, and it was expected 2 more vacancies will arise in May 2010. As desired by the competent authority for rechecking all aspects, that is date of birth, educational qualification, technical qualification, caste certificate, etc. of the candidates shortlisted on the basis of merit in the examination held on 23rd of February 2010, the administration has checked all the documents of the top 4 candidates and found that all the documents of the following 3 candidates are in order. Now, my lord, they are raising this point of, my lord, document. My lord, page 67, the first paragraph. Sri Somrat Chatterjee, that is the, my lord, the petitioner before your lordship, ranked 4th in the submitted documents of passing Madhyama examination from Bihar Sanskrit Shiksha Board, Patna. In this connection, it is stated that the administration verified the recognition of the said board from the Department of Secondary and Higher Education, Ministry of Human Resources Development, Government of India website, and found that the said board is not a recognized board of the school education. Hence, the administration is in the opinion that the said Madhyama examination is not equivalent to secondary examination. My lord, this is first time they reveal in the reply. My lord, there is no, my lord, the story of vacancy anymore. Now it is, my lord, on with regard to eligibility on the basis of my Madhyama certificate. And my lord, I will show your lordship from the, my lord, documents, my lord, collected of this respondent institute itself, page 93, my lord, where they sought for a clarification from the Human Resource Development Department of Bihar, where they
What is the next recruitment process has begun at which time?
My lord, after, as per this, my lord, reply, the next recruitment process started, my lord, the next year.
Next year means?
My lord, kindly gives me a minute, my lord.
2012.
2012.
What is, how can you be allowed to agitate the matter now? Just see your conduct. 2012, you file a writ petition, dismiss, you don't care. 2 years later, you move the tribunal. Then you withdraw and then come to the High Court, get a restoration. This is the way. How can you be considered by any forum?
My lord,
It cannot be. Perhaps the tribunal must have considered this aspect of the matter.
the
Yes,
tribunal
yes, Lord,
has,
everything
my
was
lord,
there.
rejected my application on the time of, my lord, on the ground of lapse, but
No
my lord,
way.
my humble submission, I did not approach the completely wrong forum. Maybe, my lord, I approached this honorable court, my lord. At that point of time itself, my lord, this
Your
was,
conduct lacks bona fide.
my lord, in 2012, my lord, there was a confusion.
When 2012 you have filed a writ petition, why did you go to the tribunal in 2014?
Lord, since in 2012, my lord, there was a confusion that, my lord, I was not an appointed person.
So you can avail all the forums at the same time.
I sought for the reason, my lord, I thought that maybe this.
We are not on merits. We are not on what you have sought or not sought. You have approached the writ court in 2012. And then after 2 years you filed an OA. Why not file another writ petition? This is the way. And when you get it withdrawn from the tribunal, then you come to the High Court, then again you start the things. Restoration, then in 15 you file a fresh writ petition.
Kindly consider that the first writ petition was, my lord, dismissed on the ground of default, my lord.
Yes, you were not diligent.
My lord, that, my lord, your lordship will consider.
Even if it was dismissed for default, why did you avail the tribunals? Why did you invoke the tribunal's jurisdiction? Did you know that it had been dismissed in default?
My lord, yes, knowing.
Then why didn't you get it restored? We are looking at your conduct. You invoked the High Court's jurisdiction. It is dismissed for default. And then in 2000, after you withdraw it from the tribunal, then you say that now I have come to know I want it restored. So why did you go to the tribunal?
Only if lordship may only consider that since the writ petition was not dismissed on the ground of merit, my lord, it was my understanding that, my lord, it was dismissed on the ground of default would not preclude me to, my lord, approach before the tribunal.
Then you should not have withdrawn from the tribunal. You should have asked for an order on merits.
The tribunal, my lord, insisted that you.
We don't.
Unless
These submissions we don't entertain.
My lord, that is the order I
Sorry.
have annexed, my lord. That is the order I have annexed.
No, let us see the order.
No, my lord.
Come to the tribunal's order.
The initial order of the tribunal, my lord.
Yes. Learned applicant wants to withdraw with liberty to approach. Come to page 44.
Yes, my lord. I bow down, my lord.
Then how can you say? This is the order.
Everything quite considered, Lordship. Learned.
Such a person, what can be done? The next recruitment process, where have they stated was
in the reply, if your lordship may consider.
No, you have stated in writ petition application. 12 started, you have stated.
Next recruitment process, my lord, they have only mentioned in paragraph, my lord, 4.2 at page 68 that later on council video letter dated such and such, dated 24th of August 2010, revised the cadre strength. But, my lord, when the next recruitment happened, that has not been, my lord, clarified in the reply.
No, it is there. Sir.
You have stated.
That is not in dispute. We are just trying to look for the date. There is no dispute that a subsequent recruitment process has not been initiated. Fresh advertisement was issued. We have seen somewhere in 2014, even before you filed the OA. Probably before the first OA also.
এই রিপ্লাই এর মধ্যে তো পাওয়া যাচ্ছে না।
You have a copy of your OA 351 of 2014.
My lord, I have annexed that.
351 of 2014.
351. My lord, 351. As of now, my lord, we do not have.
When did you file it? What was the date of filing?
My lord, the OA 351.
Yes.
My lord, 351 was filed, my lord, in 2014, my lord.
That is not a date.
My lord, I am sorry because I
We are asking you for the date.
Lord, we can produce, we can submit, my lord. We can produce.
Date 11. Yes. The date of the relief itself was infructuous in the OA. What can be done? You have sought no relief with reference to the fresh advertisement. How this relief can
Page 41, Lordship, Annexure 6.
be your prayer number 2. You are seeking quashing of that letter of 2011. Anyway, that is delay or no delay, that's a different issue. Your prayer number B, to grant an appointment. Now, how it can be done? Those vacancies have already been taken in the next, much before you file this OA. Have you, where is, in the OA, where have you said that fresh advertisement has already been issued?
Page 41, Lordship, the advertisement letter, Lordship. Page 41, Annexure piece A6.
Where is this OA starts from which?
OA starts from, my lord, page 23.
Yes.
This is the current OA.
This is the current OA. 1812 of 2015. The fact starts from, my lord, page 26, paragraph 4 onwards, my lord. Lord, I am thankful to my learned senior, my lord. Page 41 is the, my lord, notification of the next recruitment. Dated 8th of November 2014.
Correct. So you should, at least you should have disclosed that. You have not even disclosed
Page
that in your
41,
OA.
my lord, page 41 was already, my lord, annexed to the original application.
No, sir.
Page 41 is, my lord, the part of the, my lord, original application. Because I have annexed the entire original application.
But you have not said anything in the OA. We are going through your
Paragraph,
application.
my lord, it has not been stated.
So what good is this?
But 41 was annexed, my lord.
We don't know. If there is nothing said in the OA, then how we can presume that it was annexed? A1 is, but this is perhaps the earlier advertisement.
My lord, dated 8th of November 2014, your lordship will find from the, my lord, underlined portion, page 41 at the very first paragraph, my lord. Advertisement number REC/1// my lord, 2014.
See, there is only one annexure that you have enclosed with the OA. Page 30, annexure A/1. No, there are 6 annexures.
My lord, there are 7 annexures.
6. 20.
Lord, your lordship will find the list of annexures at page 23 of the OA.
Page
23. Page 23 is the index of annexures, my lord. Total 7 annexures were annexed with the original application A6.
There is no mention of this.
My lord, copy of notification is mentioned A6. Page 17 to 18, my lord, this is the 41 is the, my lord, page 17 of the original application. A6.
Oh, yes, you have 4.7 at page 29. In 4.7, you have you sought no relief. What can be done? Nothing can be done now. Probably this process is also over. What was your prayer? You were seeking quashing of this letter of 28, 22, 8, 11. On what ground? What is the ground for challenging?
Ground at page 30, my lord.
No, what? Just tell us. What was the ground for assailing?
My lord, legitimate expectation, reduction in the number of, my lord, advertised vacancies or notified vacancies, refusal to consider the candidature of the applicant, which is arbitrary, and my lord, this Motilal Padampat sugar mills, my lord, had been cited.
Legitimate expectation. Motilal Padampada on legitimate expectation.
Motilal Padampat was on, my lord, promissory estoppel.
When a representation is made, then a person is estopped, the same time giving a legitimate expectation on the other side.
Legitimate expectation, probably, my lord, the, my lord, notified vacancy. My lord, they cannot reduce the number of notified vacancy.
Where is the reference to Motilal Padampada?
My lord, page 30, ground D. My lord, the last ground. From the response of the, my lord, the respondent, it was not on the basis of vacancy, my lord. It was, my lord, it was, my lord, on the basis that my eligibility criteria, madhyamya, was not considered, my lord, which, my lord, at page 93 is a clear indication from the government of Bihar. This is, my lord, a clarification being sought by the respondent from the government of Bihar. Whether this madhyama, this certificate from the Bihar Sanskrit Shiksha Board is valid or not, my lord, they are informing. Page 93, my lord, these I have obtained after filing of RTI application. My lord,
there is an issue regarding your qualification.
Qualification. This is what, my lord, transpired from the reply.
That's because you have made a false representation. Come to page 60, what you have stated in the attestation form. You could have said there that you are a Madhyama.
Page 51 is stated that he is a matriculate.
Matric is matric. Madhyama is Madhyama.
My lord, the school that I have mentioned is Rameshwar Street Primary.
That means there is a disclosure.
My lord, high school.
Obvious deception.
My lord, Bhagalpur is.
Deception is obvious. Even if not false, it is a deceptive. Why should you say matric when you know that you have got a Madhyama? You are holding the degree and you will say that I have this degree.
My lord, is equivalent to matriculation, matric examination. It is, my lord, reflecting.
It says kaun si pariksha uttirn ki, examination passed, that you have filled matric. You could have said Madhyama. The advertisement doesn't say equivalent. Advertisement only says metric and above.
मतलब मध्यमा is
After seeing everything, that is why we are observing that perhaps you don't have a case.
kindly consider, my lord, this is not a, my lord, misrepresentation on my part, my lord.
Oh, it is a clear, and we will hold that it is a misrepresentation, a conscious misrepresentation. You are filling an attestation form. See the last page. See the last page, page 63. Particulars for furnished are correct. This is a correct particular furnished by you. Tension is obvious from your conduct.
Should I kindly consider if the criteria is eligibility criteria is high secondary, and I say that I obtained ISC, which is equivalent to high secondary, my lord, that is, my lord, to my understanding, is not misrepresentation.
That is to our understanding also the same thing. But provided you say that. If you have an ISC and you say something else, then our understanding differs. Otherwise, our understanding is at item with your
Consider matriculation is the, my lord, the
clear misrepresentation. It's a clear and conscious misrepresentation by a literate person claiming a benefit of a degree or qualification. These things can't be overlooked. It's a different thing that even if the advertisement does not mention equivalent, whether you can claim that since it is a recognized, I will claim equivalence, but then you have to come bona fide and clear, not deceptive and fraudulent.
My lord, matriculation, my lord, in 2009, my lord, there was no examination, at least in West Bengal, my lord, which is called matriculation. Here, my lord, we have secondary equivalent.
It's not a state government. It's not a state government advertisement.
So, my lord, that is.
And the person who has applied, he has not applied from this degree on West Bengal.
So, my lord, the
He has
matriculation-
applied from a degree somewhere else.
Who asked
This
to
is not
stand,
available.
my lord, secondary-
This stand is not available to him. If he was a West Bengal applicant, then perhaps he could have said this. This is not available to him.
Lordship, may kindly consider that matriculation, so far as this advertisement is
We will not go into all that. That's hardly relevant. Your OA was infructuous to begin with. You never made any prayer with reference to the subsequent advertisement. The recruitment has already attained finality. Where is the question? All issues apart. If we go
that
into all,
vacancy which was not filled up, my lord, your lordship may kindly consider whether
oh, impossible.
filled up by a subsequent, my lord, ballot.
Has to be carried forward. This is very obvious everywhere. It's axiomatic.
Without any merit list, and only when I submit the representation, they come up with
That you could have. That's why we are saying you could have done it, but you did not. We don't know why you were sleeping. You were sleeping idle, dismissed in default. 2 years later, you file OA without getting it restored. Then you come back, get it restored. Then you file a second OA, and then you don't pray for any relief. Such a person, what can be done? Nothing can be done. All those who have participated diligently, now they should suffer because of you.
Apparently, my lord, only 3 persons were appointed.
Sorry. Yes, take
Apparently, my lord.
Third Learned Counsel for the writ petitioner.
Item number 12 and 14.
Item number 12.
Lordship, item number 12 and 14, learned conducting advocate is seriously ill. Conducted advocate is seriously ill, Your Lordship. Due to his illness, may I pray for not this week, Your Lordship. 12 and 14.
I'm for respondent, my lord.
Why two rate petitions?
I have been just instructed for taking not this week, Your Lordship.
No, you said 12 and 14. Why? 14 is with 12.
Your Lordship, 14 is for filed by him only, Your Lordship. He is the conducting advocate in 14, item number 14 also.
When it is called, then you mention. In presence of.
हाँ चलो सर.
Your Lordship, this matter, Mr. Ujjwal Rai is appearing for the petitioner because he is laid in another court. I am praying for not today only, Lord.
Ask him to come. Where is the speaking order? 16:1. Where is the order passed in OA 242?
The prayer for re-engagement.
How many petitioners are there? How many petitioners?
Casual basis. And status of status. In the petition paragraph number 3.
What is the prayer in the OA? Where is the OA?
The same order has been passed in other cases. There is in page 2.
I'm praying only for short pass over, your lordship. Only short pass over. Mr. Rai is led in court number 16, your lordship.
Yes, that's why we are waiting. Where is he?
There is one fixed matter in three payment in court number 16, lordship. I'm praying for only short pass over, your lordship. Only short pass over.
Ask him to come. Let him come. Call the next case. Let him come.
14.
Lordship, 14 also not this week.
Same as 12. 14, there is no respondent.
I'm for the appellate, my lord, petitioner. Let the affidavit service I'm placing. I don't know whether other side is here or not. Let me place my case, my lord, first, if your lordship so permit me. There is a school at Farakka barrage that was controlled by the Farakka. Under the Ministry of Water Resources, Government of India. 3 teachers were appointed on contractual basis in the year 2009. Your Lordship, kindly see the order of the tribunal at page 146.
What happened on 10/7? What
Madam?
happened on 10/7?
Your Lordship, kindly first turn to page 3 of my application. My Lord, your Lordship, kindly see.
The order you have challenged
Yes,
fixes a next date of 10/7.
10/7.
What happened on 10/7?
It was adjourned till 19th August.
19?
August.
So why have you not complied with the order?
Because there is no post as such, my Lord.
So therefore you will sit over the order, or you're required to file a review or appeal or writ petition, or you will decide what is to be done.
They were appointed as purely on.
We are not on that. When there is a direction, how can you sit over the direction?
No, we are not sitting over.
You are sitting over the direction.
Two candidates were taken.
What is the direction? Tribunal's direction.
3 persons should be appointed.
Then why they have not been?
Till your Lordship, kindly see the order first.
Yes, we are looking at the order. We are looking at it. Consequently, the advertisement issued to appoint fresh teachers on contractual basis is quashed. So no appointment on contract basis.
No.
In case you take a decision to hold a regular selection, you will give them age relaxation. They may be given appointment also. The applicants may be given the benefit of age relaxation till the regular selection is made.
The regular selection.
Yes. The department continuous with the decision to engage the teacher on contractual basis. The applicant should be allowed to continue on the post. So why they have not been allowed?
No, they have been allowed and they're working there. 2 out of 3. The third one, my lord, your lordship kindly appreciate this. The third one was appointed by the UPSC. There's direct appointment that is not on contractual basis. That is not the contractual basis, on the basis of contract. No. They are direct. In the meantime, there is no vacancy further. And now.
So therefore you decided the tribunal's order is wrong.
No, I'm not saying
That's
that.
precisely what you are saying.
I'm saying, my lord, that since
You have to comply or you have to take remedial steps, either by filing a review if there is an error of record or by going in a writ petition. Can you sit over the order? Who are you to decide?
Partially we have complied with the
Then
order.
why partially?
Because the third one, prior to this, she was appointed. The other person.
We don't know the tribunal's order is right or wrong. We don't care. There is an order, it has to be complied. It is not for you to say that the order is wrong.
That was in the contempt petition, my lord, your lordship.
You go and face the consequences. What can we do? You go and face the consequences.
Only thing is, my lord,
If this is your attitude, you should face the consequences.
Yes, learned tribunal, my lord, did not consider my reply to the.
So therefore, don't comply with the order. Face the consequence.
That is the reason we have come before your lordship.
You have to face the consequence. You have to face the consequence. Where is the question of giving you any relief?
Remediless, because we have come to before your lordship.
You cannot challenge the contempt order unless you have challenged the original order. You cannot.
Your order, we could not.
Then you have to comply, or you have to face the music. What can be done?
No vacancy. What else?
Sorry, we can't do anything. We don't know how you will comply. We don't know. That's not our concern.
Yes.
Our concern is to see that once an order has been passed, right or wrong, it has to be complied. There is no way out. Unless you take remedial measures, which you have not done. You think that you are above the tribunal, you will decide what can be done in compliance and what cannot be done in compliance. You cannot decide what has to be done in compliance and what not.
We have cited judgments.
Go and cite more judgments. Go and cite more judgments. Who is stopping you? Go and cite more judgments.
That is the reason, my lord, we have come before you.
Sorry.
Only for this,
nothing.
Only clarification of that.
No clarification in a contempt. You are filing a writ petition against the contempt order. There is a question of clarification. Right or wrong, it has to be complied.
If the contempt order
very well
is not sustainable, my lord, your lordship can interfere this.
We don't know how it is not sustainable. Because you think that the original application order was not sustainable, therefore contempt order is not sustainable. This is a unique argument which we are hearing today.
Not that.
That the tribunal has not considered this and that.
Not that.
So you will sit over the OA order passed in the OA.
Factual aspect, your lordship kindly appreciate.
We are not going to go into the factual. This is the order has to be implemented in letter and spirit.
Yes.
Go and show it to the tribunal.
Partial.
So we'll record that you admit that you have only partially complied. We'll record this. That you admit that you have only partially complied with the order. Then you go and face the music.
And also, my reason, your lordship kindly, my submission may be recorded.
We will not look into the reason. Can we tell us the scope we are exercising? Can we look into the jurisdiction? Make a legal submission.
Yes.
Make a legal submission. Yes. A writ petition arising out of contempt.
Yes.
And in that you say that the OA order is not correct. How we can look into?
You have not said that.
That is precisely what you are saying.
No, not so, my lord. Because contempt, yes, admittedly there is a contempt petition and they got the order. And they got the appointment also. Because we cannot give her appointment. Though we are...
Don't give. Don't give.
Though we are willing to give appointment, but there is no post.
See what you will do.
Order, my lord, kindly.
That is why we are saying. You are saying that the order of the tribunal is wrong. There is no vacancy how the tribunal has directed.
As a whole, no.
Only part of it is wrong. So that part which is wrong, you will not comply. Unique argument is being made.
No, not that. Two persons were taken as a teacher there. The third one in the meantime.
Third one was not taken. This is the third time you are saying.
Because of the UPSC candidate came and joined there. There is no vacancy as such.
Then what were you required to do? Just ignore the tribunal's order because UPSC has sent someone.
No, not that. I'm not saying.
That's precisely what you are saying. If UPSC has sent, you should have told them that there is a tribunal's order. This post we cannot give you. Whereas the other way around, UPSC has sent, therefore we will fill it with that, but will not comply with the tribunal's order.
No.
And when an action is taken under contempt, we'll go to the High Court.
Permanent vacancy, there the person was appointed by the UPSC. Regular appointment. This is for a purely temporary basis. So there is no, as such, in a school, your lordship.
It was a fresh appointment. The third vacancy was filled up by a fresh recruitment process.
Yes. That is regular appointment. This is those are not regular appointment. Purely on the ad hoc basis. Your lordship kindly.
So the third one is a fresh. Be very sure. The third one is a fresh appointment, or somebody has been posted there.
Fresh appointment from PG. Yes, that is my instruction.
All right. Then you serve a copy. Then because it has said till regular appointment is made. How long time have you taken? How long time has lapsed in between? In between the direction of the tribunal and posting of this person, how much time has passed?
Removed from the service in 2017. Their reappointment, not reappointment, fresh appointment in the year 2024. Because the students will suffer, that is the reason we had to take this contractual service of the teachers.
So why have you not informed the tribunal about this?
Tribunal specifically said that appointment, till the regular appointment is not made, they let them be.
That we have understood. That is why we are asking you, why have you not informed the tribunal about this?
We have informed.
So where you have informed? Come prepared, sir. Not today. Call the next. Sorry, this is not the way. We don't appreciate. Call the next person. Everything you have to ask him and then respond.
No, that is instruction, my lord. I cannot. Without any instruction, I cannot. Huh? If your lordship, it is affidavit service to the may
come tomorrow. Please go through it for yourself. For every query, don't ask him.
Not every query.
Call the next case.
Policy making.
Item number 16.
Say, without their instruction, I cannot.
My lord, in item number 16, I pray for.
There is a Passover matter, short Passover.
Item number 13.
I was on day. I could not.
Yes. What is the right of these applicants?
The grievance, my lord, for which, my lord, I approached before the tribunal was that the impugned order, my lord, which was used against us, which said that we could not submit any documents with respect to our claim for obtaining temporary status or the regularization.
No, you are not claiming temporary status. You are claiming re-engagement.
Yes, my lord, in the original application, my lord, the prayer would say so.
Therefore, we ask you, what is your right?
I tell your lordship, my lord, here, our names previously lordship has seen from 20.
Maybe we accept all that. Still, what is the right enforceable through a court that you must be engaged as a casual?
May I take your lordship to once the prayer of the original application?
Yes.
That your lordship will find at page number 84. May I please?
We are saying we set aside the speaking order. Still, what is your right? We are asking you.
I tell your lordship, my lord.
Let us presume for the moment that the speaking order is wrong. What right you have that you must be engaged as a casual labor? Under which provision? Under which circular? Under which order? Anybody has a right to be engaged on casual basis. That is the sum and substance of your prayer. You say sometime in 80s you have worked. Maybe we accept you have worked. How a right is created that can be enforced through a tribunal or writ that you must be engaged as a casual labor.
But I follow, my lord, what is calling from your lordship. Prayer B, my lord, may I place only once?
Yes.
To direct the respondent and or subordinate and or their agents and or their officers and each of them to consider the claim of the applicant for engagement as left out casual laborers as determined and empaneled by the concerned authorities of the Eastern Railways, taking into account that all of them working for such and such, but almost all the left out casual laborers were engaged, except the cases of the applicants through their name, though their names were duly recommended and their names were listed for engagement.
We are saying we accept you have worked, we accept there was a recommendation. What can be enforced through the court? How the court can issue a direction that you engage these persons on casual basis because some VIP has recommended. We have seen.
But
that's in the order, sir.
I tell you, lordship.
I don't know, I am not local, but he must be a VIP, therefore his name is written.
We are not, my lord. We are not. Of course not. All I was just trying to, my lord, take your lordship to only one thing, my lord, here, that this phrase as left out casual laborers.
Yes.
My lord, I tell your lordship, subject to correction, my lord, my claim was all along that this other person.
See, from what we gathered, there was engagement of. Yes, that is the order.
Yes, ma'am.
So that is the order. Unfortunately, I pinpoint things immediately.
But
fortunately or unfortunately. So I saw it, and then what is the right? Just see the order. 16 of you have gone. They have repeatedly asked you what documents you have. You say no document.
But
say whatever I had, I have annexed in the OA. The OA documents are not matching with the file. So these all are disputed issues. Now, even if we accept that you have worked for some time, 1 year, 2 years, you have been given 8 rupees, 10 rupees. What is your right now?
All I was just requesting your lordship, my lord, these persons, my lord, since my prayer, because on merit, my lord, before the original application, that my cases were not even looked into, only on the score that I could not produce the document. But on the other hand, the documents were very well annexed in the original application.
No, we are saying the documents are there.
Saying, yes, I am not reiterating, my lord. I was just saying if
what
they
can be done, how a tribunal or the writ court even can issue such a direction that you engage them on casual basis.
Oh, my lord, at least, my lord, to take the decision, taking into note of this.
That decision is taken.
But that decision subject to process of decision making, my lord, I tell your lordship, though the documents are very well there in the original application, they ignored one document. They say that is not matching.
No, come to the speaking order, page 238.
Yes.
All 16 persons they have considered.
The document I'm saying, my lord, they say that one of the documents.
No, you come to page 239. Second but last paragraphs.
Yes,
it is also mentioned here that the documents cited in the UA are not available in the office of the undersigned headquarters. Then you say that you were engaged by certain authority. They say that authority is for gazetted officers. How they could have been engaged as casual labor by this officer? So this raises disputed issues. We are saying even if we accept that document was there, you have no right.
But if my case could have been, my only place, my lord, this on which your lordship is referring, my lord.
Yes.
That on going through the above personal. 1, 2, 3.
Yes.
39.
Yes.
Going through the above personal hearing, it is found that none of the applicants has any document support to his claim. They have also not submitted or conveyed any information.
Yes, because that day you did not go with any documents. You said it is in the OA. Therefore, we are reading the next paragraph. In the next paragraph, they have considered the documents in the OA.
Mentioned here that the documents cited in the original application are not available in the office.
All right.
The undersigned.
Yes.
Or the headquarters. Not even the applicants have in them possession of any copy of the same.
So,
but
now read further.
Which indicates that all the documents are false and fabricated.
If we are saying this finding is wrong.
at the time of hearing, applicants were asked to submit the name of the colleagues who have been engaged in.
You could not say anyone with whom they could verify whether you have worked. You could have said, I have worked with XYZ. You said no.
That would be one of relevant
Now-
on the document itself.
Yes.
Searching of all already engaging staff in LO, so it is obvious that the applicants could not produce any evidence in support of their claim or could tell any specific tenure or work so that any search could be made at the office of the deputy such and such railway.
No, therefore, we are repeatedly asking you, there are two issues. One is
On
a
this point,
disputed issue of fact. This cannot be thrashed out in these proceedings. But even for the sake of argument, if we accept that these documents are there, what is to be enforced? How can a direction be issued that you engage them on casual basis?
But today, my lord, I pray before your lordship, not for direction on them to engage as casual. Only I am on this office order, which does not take into consideration the documents of the original application.
It does. It does. It says we have seen those documents, but they are not available in our office.
They say, my lord.
Please read again.
Time of
It is
hearing, the applicants
No.
were asked to submit.
No, please read. It is mentioned here that the documents cited in the OA are not available in the office of the undersigned or headquarters. Not even the applicants have in their possession. So these are the documents.
I did have the original application as well as the document at the time of the hearing when we went.
Maybe.
If they could have at least considered.
Nothing can be done. It is better they should know that nothing will be done.
All I, my lord,
Otherwise, they will keep running here and there.
This observation, my lord, would be, my lord, vague by saying that all the documents are, they could have.
Therefore, we are saying, even if we say that all this finding is wrong, what is your right to be enforced? Forget about these findings. What is the right? What direction we can issue? That engage them on casual basis.
At least they could be considered on the basis of,
Sorry.
because if they could have at least taken into consideration, or say that this is a false document, they say all of them are false.